When our clients come to see us, they only ever arrive in our office because they've got a problem. And they come and they tell us that the problem is this big. And we say, well, actually, when I look at that from every possible angle and based on my experience and my knowledge of the law, your problem is this big. But just in case we end up in some kind of litigation or even negotiation process, we first have to make the problem this big, so we've got a buffer for compromise. And on the other side, or the other sides in your jurisdiction, exactly the same thing is happening. I don't think anyone else on the planet solves problems by first making them bigger. But that's the way that the law is practiced. It's the paradigm through which we operate. So what that does in your world and in my world is invites people to put their lives on hold while the lawyers take control. But their lives are already on the boil, and it's having a profound effect on their worldview, on the way they function. And there are things that matter to them well outside the prism of the law. Historically, lawyers attempt to negotiate an outcome, and if you can't, either transition into a court process or at least operate through a prism of decision-making and resolution that is essentially litigation-focused. It puts the lawyers completely in the driver's seat. And there's lots of sound reasons for that, but there's lots of reasons why I think it's dangerous and why it's becoming increasingly unhelpful. One of the things we lawyers have to be very mindful of is that court is no longer the only option. It's out of reach for most Australians. One of the things I was most shocked by in some of the sessions this morning is the cost to estates of litigating matters. And in my world, in the family law world, it's coming from the same source. It's coming from elements of capital that are only ever reducing, and it's pointless. But there are so many alternatives available to parties and practitioners now that did not exist 10 years ago, not even 5 years ago, some of them, certainly not 20 years ago. We're fortunate to be provided with the statistics of how long you attendees have been in practice, and I was absolutely shocked by how many of you are more than 20 years down the road. Think about what practice was like 20 years ago and what your options for dispute resolution were. What the good lawyer of 2018 knows is something far beyond the law, because we are no longer the holders of legal knowledge. You can Google anything you need to know about anything legal. I have clients who've come into my office and said, well, I am in Justice X's list and I've read all of his decisions. And I think, well, I haven't. Clients come and talk to me and normal people use the word section blah 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 says this. And I think no one said that to me 20 years ago when I started out on this journey. If I sit there and explain my benefit in the terms of which parts of the Act or the court process I can recite, I offer absolutely nothing of value. But we all work in a sphere where people matter. The things that make people tick, fundamental cognitive functioning, social connection issues are profoundly important and I think are much harder to outsource to technology. Algorithms deal with the predictable and people are deliciously unpredictable, particularly in times of stress. The good lawyer knows that the times are changing and that our real value lies in being wise counsel in times of great stress. That's well beyond the scope of any piece of legislation. Come to the lawyer, here's my problem. Actually, your problem is this big. No, wait, we'll make it this big, and you should be fearful and mistrusting, and you should build a barricade around information. And that's how we're going to solve this. Oh, and when we're a long way down the track, what we might do is ask you to change gear and come to a mediation and suddenly see if you can veer towards the centre. I don't think that makes a lot of sense to people who don't understand the way the system works. In my jurisdiction, and I suspect it's not very different to yours, only about 5% of matters end up in a trial. Do you think that's reasonably consistent with your work? Those who litigate? Tiny percentage? Yeah. And yet the way we start Every single matter, the way we deal with the 95%ers is just in case you turn out to be a 5%er. Great way to make them like that, but illogical. Our clients are not driven by what Section 18 of the Succession Act says, although they might come to be driven by that, given the interesting things I learned this morning. They are driven by things that matter to them as human beings, by their hopes and their fears and their dreams and their expectations and the things in your jurisdiction that they have given their life to, the very fibre of their being. And we lawyers funnel that through a tiny little prism of the piece of the legislation that we decide matters. And the great thing that you all have the opportunity of is learning from the family lawyers who have been doing this. I've been practicing collaboratively for about 15 years, and there are things that I do now that I would never have had the confidence to do 15 years ago, but which make a profound difference to the way that that process works. So we've broken the back of it for you. We've cut our teeth on the way that we can transfer what's inherently an American process into a very different cultural and legal environment. And I think it's terrifically exciting.